My name is Norton Mezvinsky. I am the president of the International Council for Middle East Studies, ICMES. I am pleased to introduce a series of 4 webinars on a single topic that ICMES has prepared. ICMES is an academic think tank located in Washington, D.C. ICMES is comprised of people of different values, religions, and nationalities. Our common denominator is our interest as scholars in issues pertaining to the Middle East. ICMES is not a political advocacy group. Our mission is to enlighten and inform American citizens, the West generally, and global organizations and communities about the Middle East, and to inform governmental and non-governmental organizations and citizens of present and past dangers, hazards, and threats to the Middle East and global communities. ICMES plans programs, participates in conferences, promotes scholarship, and studies important Middle East issues. We encourage the airing and presentation of varied opinions of Middle East issues, and we attempt to present differing views. Among other issues, we are concerned with Israel, Zionism, and the Israeli-Palestinian conflict. Recently, a European-based organization, the International Holocaust Remembrance Alliance, IHRA, decided to spearhead an effort to expand the issue of Zionism and anti-Zionism, together with some specific criticisms of the State of Israel, into a discussion of anti-Semitism. We at ICMES have decided to address this discussion head-on. On May 26, 2016, IHRA issued and began to promote its working definition of anti-Semitism. To date, this IHRA definition of anti-Semitism has been adopted or endorsed by 36 governments, including the United States and Great Britain, as well as by numerous universities and organizations. In England, Zionist opponents of Jeremy Corbyn used the IHRA definition in attacking him and his party as being anti-Semitic. In the United States, President Trump, while in office, endorsed the IHRA definition totally in an executive order. Jared Kushner stated that the executive order, quote, makes clear what our administration has stated publicly on the record. Anti-Zionism is anti-Semitism, end quote. On March 3, 2021, the Biden administration said that it, quote, emphatically embraces the 2016 International Holocaust Alliance working definition of anti-Semitism. U.S. Secretary of State Anthony Blinken announced this statement on behalf of the Biden administration in a letter to the American Zionist movement. On July 30, 2021, President Biden nominated Deborah Lipstadt as the State Department's special envoy to monitor and combat anti-Semitism. Lipstadt, a Holocaust historian and a supporter of the IHRA definition, said in a public debate in England that the jury was still out on whether Orthodox anti-Zionist Jews, like the ultra-religious Satmar group, are anti-Semitic. Whether we agree or disagree with the Orthodox Jewish anti-Zionist views, we should understand that this statement by a highly recognized Jewish scholar is absurd. William Daroff, the CEO of the Conference of Major American Jewish Organizations, stated that Biden's approval of the IHRA working definition proves that it is, quote unquote, the gold standard. The European Commission has urged member states of the European Union to condition funding on adherence to the IHRA definition and examples. Advocates of the IHRA, moreover, have encouraged university administrations and organizations to regard anti-Zionism and certain criticisms of the state of Israel to be anti-Semitic, and therefore discussion of them should be stifled or limited. The complete IHRA definition consists of a main definition and 11 examples that explain how anti-Semitism may manifest. The IHRA definition is as follows, quoting, "Anti-Semitism is a certain perception of Jews which may be expressed as hatred towards Jews. Rhetorical and physical manifestations of anti-Semitism are directed towards Jewish or non-Jewish individuals and or their property, toward Jewish community institutions and religious facilities." 4 of the examples are classic anti-Semitism. The remaining 7 examples of explanation involved Israel. The IHRA working definition has engendered enormous opposition and pushback from Jewish and non-Jewish scholars, political leaders, and other concerned parties. We at ICMES have prepared a 4-part series of webinars on the veracity and ramifications of the IHRA definition. Many of the opponents of the IHRA definition claim it impedes freedom of speech by tying certain opinions about the state of Israel to be anti-Semitic. The definition's proponents claim that since the definition defines itself as non-legally binding, it would not impact any legally granted freedom, including freedom of speech. In our first webinar, Professor Louis Seidman will address this question. In our second webinar, Rabbi Yaakov Shapiro will critically assess the IHRA definition and provide our alternative and superior ICMES definition of anti-Semitism. Our third and fourth ICMES webinars will feature perspectives from Palestinian and Israeli Jewish points of view. Dr. Rada Karmi will discuss Palestinian opposition to Israel as opposed to opposition to Jews and Judaism. Professor Benjamin Beit Halachmi will focus upon the development of Zionism and will suggest a way to reconcile the conflict. We shall now go directly to the first webinar. Rabbi Yaakov Shapiro will interview Professor Louis Seidman. Louis Michael Seidman is the Carmack Waterhouse Professor of Constitutional Law at Georgetown University Law Center in Washington, D.C. He is a widely published scholar. In addition to his many books on judicial review and criminal law, he is also known for his constitutional law casebook, which he co-authored and which is used as a textbook in many law schools. Following the interview with Professor Seidman, Professor Don Wallace and attorney Timothy Moynihan will present short comments. Don Wallace is chairman of the International Law Institute in Washington, D.C., and is professor of international law at Georgetown University Law Center. He is active in numerous organizations and societies. Among his many academic awards, he was the recipient of the Henry Leroy Jones Award for Outstanding Achievement in International Law. Timothy Moynihan is a specialist in the First Amendment, Bill of Rights, and constitutional principles, criminal legal defense, and international biotechnology law. He was awarded Man of the Year by Yeshiva Gedolah of Waterbury, Connecticut.
Good morning, Professor Seidman. How are you today?
Good morning, Rabbi. I'm just fine, and I'm so grateful to you for inviting me to participate in this session. I think I want to start by saying something about why this is so important. There's no doubt that in recent years, there's been a disturbing uptick in anti-Semitism in this country and around the world. And as a Jew, I have a special concern about this, but the truth is we all need to be concerned, and we need to join together to fight this scourge. The trouble with the IHRA's definition, though, is that if it were adopted, I would have to label myself not just a proud Jew, but also a proud anti-Semite. Or to put the same point a little differently, if anti-Zionism is really anti-Semitism, then, at least in my view, anti-Semitism is a respectable and indeed a laudable view. That kind of conflation is, to say the least, a step in the wrong direction if we're to fight the immediate and serious danger of real anti-Semitism. So what is the IHRA definition? The truth of the matter is the definition is so vague and innocuous as to be virtually meaningless. It says anti-Semitism is a certain perception of Jews which may be expressed as hatred toward Jews. So that definition leaves mysterious what exactly the perception is or how else it might be expressed. Key words in the definition, like Jews and hatred, are left undefined. By itself, that definition just cannot function as a legal standard. The problem is that the definition is followed by 10 examples, 7 of which relate to Israel. Now, the examples are labeled illustrations, but I think that's somewhat disingenuous since the definition is so vague that it really has no meaning at all without the examples. Now, some of the examples are unobjectionable, but many of them are not. And perhaps the most egregious example of anti-Semitism, according to this definition, is, quote, denying the Jewish people of their right to self-determination, e.g., by claiming that the existence of a state of Israel is a racist endeavor. That example is egregiously wrong in my view, because it assumes that all Jews have exercised their right of self-determination by creating the state of Israel, when in fact there were many Jews, both when Israel was created and now, who oppose its creation and oppose its continued existence in its present form. For people like me, Jewish identity is wrapped up with a commitment to social justice that is incompatible with the way Israel functions today. Worse yet, the drafters try to have it both ways. Having proclaimed that Israel manifests the collective action of the Jewish people, it then gives as another example of anti-Zionism, holding Jews collectively responsible for the acts of the state of Israel. Well, if Israel is a manifestation of the collective right of Jewish self-determination, then it would seem to follow that all Jews are collectively responsible for its actions. Of course, all Jews are not collectively responsible for its actions, and that's why it's not a manifestation of Jewish self-determination. Now, it has to be said, we live in a free country, so anyone has a right to advance any definition of anti-Semitism that they choose, no matter how dangerous or wrong-headed I happen to think it is. The problem is that many governments, including our own or parts of our own, have endorsed this definition, and proponents of the definition are engaged in a vigorous campaign to have it incorporated into American legal standards. So what laws might the definition apply to? 2 statutes loom large. One is Title VI of the 1964 Civil Rights Act, which provides, quote, no person in the United States shall on the ground of race, color, or national origin be excluded from participation in, be denied the benefit of, or be subjected to discrimination under any program or activity receiving federal assistance. Now, one might quarrel with whether ethnic religious groups like Jews count as a race, but courts have interpreted statutes like this to include them. And since virtually all colleges or universities receive federal financial assistance in some fashion, they are covered by the statute, and exclusion or discrimination against Jews is therefore prohibited. If anti-Zionism is equated with anti-Semitism, then, for example, a statement by a university president that Israel is a racist identity, or the refusal of a Palestinian rights student organization to admit Zionism might jeopardize university federal funds. The second statute is Title VII of the 1964 Civil Rights Act. It provides that it is an unlawful employment practice for an employer, quote, to fail or refuse to hire or discharge any individual or otherwise to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin. The statute has been interpreted to outlaw practices that an employer tolerates that create a so-called hostile working environment or constitute harassment based on one of those protected characteristics. So, if anti-Zionism is equated with anti-Semitism, an employer might be subject to suit if it tolerated managers hanging posters in their offices, claiming or favoring a one-state solution for the Palestinian problem, or if a Palestinian rights organization refused to hire people who endorsed the current state of Israel. Simply as a matter of statutory construction, I think it is important to understand that this is a manifestly absurd reading of the statute, of either statute. It's true, of course, that there are some anti-Zionists who are anti-Semites. There's no use denying that. But there are also many Jews, me as it happens included, who are anti-Zionists. And for that matter, there are many Zionists who are anti-Semites. For example, some fundamentalist Christians who favor locating all Jews in the state of Israel so that those who don't convert to Christianity can be burned during the rapture, the so-called rapture. So there's simply no one-to-one and automatic connection between anti-Semitism and opposition to the state of Israel. It should just go without saying, but apparently it needs to be said, that both Zionism and anti-Zionism are not nationalities, they're not religions, they're not races. They are instead political positions. Suppose, for example, that during the apartheid period in South Africa, a university president proclaimed that South Africa was a racist state and needed to be dismantled. The statement would not be banned by Title VI because it is a position about the stance of the South African government, not a position about the equal rights of South Africans. Similarly, if today Human Rights First, a human rights organization, refuses to hire people who endorse the Chinese genocide against the Uyghurs, they're not violating Title VII by engaging in nationality discrimination. Now, the response made by proponents of the definition is that Zionism is essential to Jewish identity, that it is what makes people Jewish, and that discriminating against Zionists is therefore necessarily discriminating against Jews. That position overlooks the fact that many proud Jews are not Zionists, but beyond that, it is not and simply cannot be true that these statutes are violated whenever anyone discriminates against what someone else thinks is essential to their religious identity. Suppose, for example, that Planned Parenthood refuses to employ as staff workers people who oppose abortions. Opposition to abortion is central to the identity of some, although importantly, not all Roman Catholics, but it doesn't follow that Planned Parenthood has violated Title VII. In fact, for some Palestinians, although importantly, not all Palestinians, the creation of a Palestinian homeland in territory now occupied by Israel is essential to their national identity. But it hardly follows that IHRA itself has violated Title VII if it refuses to hire individuals who deny the right of the state of Israel to exist. After all, what's sauce for the goose is sauce for the gander. The distinction drawn by these statutes is absolutely crucial. If campus Palestinian rights organizations say they will not admit Jews as members, we have a Title VI problem. If Planned Parenthood says no Catholics need apply, that's a violation of Title VII. If a university president says the Jews are not entitled to a homeland because they are dirty, disgusting people, the government should cut off funding for his university. But neither Title VI nor Title VII prohibits people from taking positions on political questions, no matter how central those positions are to some members of a particular nationality or faith. And you know what, Rabbi? It's actually worse than that. Apart from statutes, the federal Constitution creates a First Amendment that guarantees a right to freedom of speech on issues of controversy. And the future status of Israel is nothing if not a subject of controversy. Especially in a university setting, we have a long tradition and a long line of legal cases permitting and in fact encouraging open and strong debate about a wide variety of views, including, by the way, expressions of really unpopular viewpoints. Suppression of anti-Zionist speech is not just wrong as a matter of statutory construction, it's unconstitutional, at least if done by government oppression. And to return to my original point, equating the crucial fight against real anti-Semitism with an unconstitutional effort to suppress free debate, even if it makes some people really uncomfortable, is a tragic mistake that risks the success of the fight against anti-Semitism itself. And with that maybe too long introduction, why don't we have a conversation about the issues that all of this poses?
Well, I don't think it was. The only thing I disagree with in what you said is that you said in your introduction may be too long. I don't think it was too long at all. I want to clarify something. See, the IHRA definition does say that criticism of Israel is okay, but anti-Zionism, meaning Israel is a racist endeavor, it should not exist, that's not okay. Now, how they parse that is a different story, but the examples that you gave, correct me if I'm wrong, that when you say you said you're an anti-Zionist because your Jewish identity precludes your agreeing with the way Israel functions. You use the word the way Israel functions. Or you said that creating a Palestinian homeland in part of what now is Israel. All of these things, the way Israel functions, some decisions that they make, or that the occupation is bad, the IHRA definition, the way even the Zionists read it, would not preclude somebody holding those positions. The positions that it would preclude somebody from holding, that would consider somebody an anti-Semite, was that Israel should not exist, perhaps not as a Jewish state. It's ambiguous about that. But saying Israel should not exist, that is the maintenance of Israel, I think the words of the illustration in the IHRA definition is maintenance of a state of Israel, not even the state of Israel, maintenance of a state of Israel, or the existence of a state of Israel, is a racist endeavor. Are we talking, just to clarify, we're talking about anti-Zionists that hold such a position, not merely that Israel's policies should be changed, but that Israel's existence should be changed?
So thank you for that clarification. I think it's really important. I don't know how relevant this is, but maybe it might be useful for me to state my own views for whatever they're worth. So I personally believe that the state of Israel is a racist endeavor. It systematically treats as second-class citizens roughly a fifth of the population because of their nationality, and it's engaged with regard to the occupied territories in what I think could only be described as an apartheid policy. And in terms of Israel's future existence, my own view is that what there should be in that territory is a unified state that is non-sectarian, non-religious, liberal, with strong protections for minorities. And frankly, I don't see how a state like that could have the name Israel, because that is an expression of a national identity describing only some of the people who live there. Now, that position might be right or wrong, but I think that the definition or the examples in this policy would make it anti-Semitic. And right or wrong, it seems to me to be at least a perfectly legitimate political position that ought not to be suppressed, but ought to be debated.
I have a question. I see an ambiguity in Title VI and Title VII. You mentioned that the officially listed protected classes in Title VI and Title VII don't include Jews. In fact, Title VI doesn't even include protection of religious groups. Yet Jews were included in Title VI in the eyes of the law as a protected class. What this says to me is that maybe we can't have our cake and eat it too. If we say, well, look, Title VI only protects certain classes and not others, then if we're taking that literally, Jews are not protected either. Whether you consider Jews a religion like I do, or you consider Jews a race like Vladimir Jabotinsky did, or somewhere in between. But in the eyes of the law, for whatever reason, I'm asking you what the reason is, they consider Jews protected under Title VI. If that's true, it would seem to me that that gives us a little flexibility, mystery. There's a mystery. There's this field with this variable with an unknown value called Jews that are thrown into Title VI. And now it's easy for something like the IHRA definition to say, oh, you know what, we're going to fill the variable called Jew, this word, with the meaning that we give it, which is just as valid as anybody else's meaning. And therefore, although Title VI, somebody's going to come and claim, well, Title VI doesn't cover Zionism. Well, you know what? Title VI doesn't cover Jews. So why should it cover Jews not according to the Zionist definition any more than it does Jews according to the Zionist definition?
So that's a really interesting question, and I'm going to give you a legal answer. Mm-hmm. And pardon me if I get too far into the weeds here, but
please, that's
it's a little complicated. So the Supreme Court is actually not ruled on whether Jews are covered by Title VI. It has ruled that Jews are covered by other civil rights statutes that were drafted in the 19th century. And what the court held was that whatever our view about groups like Jews are now, in the 19th century, the word race meant ancestry, and Jews are covered as a category of ancestry. Now, what makes this complicated is that Title VI was not drafted in the 19th century. It was drafted in the 20th century. And so we don't have a clear ruling from the Supreme Court about this. What we do have are some lower court rulings holding that Jews are a race for purposes of Title VII, and therefore presumably also for purposes of Title VI, because race includes ancestry. Now, I'm not going to express a view about whether those opinions are correct or not, but assuming they are, I think it's pretty clear that the word ancestry does not include a set of political beliefs about Zionism. Ancestry has to do with genetics. It has to do with who your parents are. And last time I looked, a propensity to Zionism was not genetically transmitted. So under that definition, under that reason why Jews are included in Title VI, I think it's pretty clear that anti-Zionism is not included.
Can I get a little more into the weeds as long as we're there?
We can get as deep as you want to get.
Okay. This is a bit worrisome to me on the face of it, because Jews accept converts to Judaism. Our last president had a daughter who was one of them. The Supreme Court of Israel recently ruled that even non-Orthodox conversions, they will recognize as Jews, which means that according to the Jewish religion, even according to the Reform religion and the conservative religion, Jews are not all ancestrally Jewish.
So the first point is Title VII protects against discrimination based on both race and religion. Title VI does not protect against religious discrimination. So insofar as we're talking about Title VII, a convert to Judaism is covered because that is a religious conviction. But insofar as we're talking about Title VI, the framers of Title VI left, for whatever reason, rightly or wrongly, left out religious discrimination. So people who claim status as Jews solely because of their religious convictions are not covered. People who claim that they're Jews because of their ancestry, at least according to these lower court decisions, are covered.
So that would really complicate the situation. There are all sorts of different people who claim they're Jews for different reasons. Somebody like Ivanka Trump, for example, if she would be a college kid on campus, you're saying she would not be covered under Title VI. Her father was Donald Trump. She doesn't claim to have Jewish ancestry, nor do...
Look, first of all, Rabbi, I want to say, as brilliant a rabbi as you are, maybe you want to be a lawyer also, because you're pretty clearly pretty adept at these legal distinctions. But here's what I would say about that. A Catholic university under Title VI can discriminate in favor of Catholic students and not admit Protestant students. Again, maybe that's right, maybe that's wrong, but that's what the authors of Title VI allowed. So that's what the authors of Title VI allowed. So yes, insofar as Title VI is concerned, a private university can discriminate based on religious affiliation, not based on race or nationality, and therefore perhaps not based on ancestry, but they can discriminate based on religious conviction. Now, that's not true for Title VII. Mm-hmm. Title VII also includes religion, but Title VI does not.
Okay, so it sounds to me that some of the Zionist arguments for the IHRA definition are really counterproductive to their own cause, because like I said, there are many different definitions that different people give as to what a Jew is. Shimon Peres said that a Jew is somebody, not somebody whose father is Jewish or whose mother is Jewish, and the rabbis also have no rights to say who's a Jew. You know what a Jew is, Shimon Peres said? Somebody who lives in Israel, sends his children to the army, and even has some of them maybe even die for Israel. So if we're going to define a Jew, or Ben-Gurion. Ben-Gurion said, when they nailed him to the wall and said, well, what is a Jew? Give me a definition, because Israel was in a similar position when they had to define legally what a Jew is for the law of return. He said, Jews don't have definitions. Those are the real Jews. As some Jews believe that Jews are a religious collective. I'm not one of them. Jews have no definitions. Those are the real Jews. I am what I am. So if there is a discriminator, or somebody that gets up, an anti-Semite that says, you know what, I am an anti-Semite. I believe Ben-Gurion's definition of Jews, which is nothing, or I believe Shimon Peres's definition of Jews, which is nothing, or I believe those Zionists that, or Theodore Herzl, that said a definition of a Jew is somebody who the anti-Semites hate. None of these, or Jean-Paul Sartre said the same thing. So if you use any of these definitions of Jews, Herzl, Ben-Gurion, or Shimon Peres, or one of these type of definitions, and you get up and say, look, I'm an anti-Semite, and I know that I'm making this campus uncomfortable for Jewish people, but this is my definition of Jew. And anybody that fits into this definition, I think they don't deserve a homeland. And not only do they not deserve a homeland, these people are bad people, they're murderers. Is there anything wrong with that under any law at all?
Well, if what we are talking about is hatred of Jews as Jews, that's certainly covered by Title VII, and probably covered by Title VI. The question of what a Jew is famously contested. I think you and I could have I hope, friendly but discussion about that for hours and hours, although I think we might well end up disagreeing. But fortunately, I don't think the law has to settle that. And indeed, I think it's really important for the law not to settle that. What the law does is it doesn't protect Jews. It protects, Title VII protects against discrimination based on religion. And so if you are against somebody because they are a Jew, however you define it, that's anti-Semitism, and that's a violation of Title VII. If you're opposed to somebody, if you're opposed to a particular political position and won't hire somebody because of their political commitments, that's not covered by Title VII. So again, to give you an example of nationality discrimination, a Zionist organization is not discriminating against the Palestinian nationality by excluding people who believe that Israel has no right to exist. They have the right to do that because that's a political position.
But, okay, so not to belabor the point, but if Title VI we're talking, does not include Jew per se as a protected class. It only protects ancestral descent. And somebody says, both the person discriminated against and certainly the discriminator, that's not what I mean when I say Jew. You know what? I won't say Jew. I'll say people who believe in Judaism. It's a belief. I don't care what their ancestry is. It's a belief. And therefore, the people who I am saying are rotten, disgusting people and don't deserve a place in this country regardless of their ancestral descent, if they believe in a certain religion, or they're called Jews, because the word Jew isn't something that's protected. If the word Jew has no definition, or let's say, I'm not going to use the word Jew, I'm going to replace it. I'm going to say people who the anti-Semites hate, as Theodore Herzl said. It's not that you're a Jew and therefore the anti-Semites hate you. The anti-Semites hate you and therefore you're a Jew. And the Zionists will say, well, you know what? See, this is what they're saying. They're saying, you have a definition of Jew. Professor, you just said that we could friendly, definitely. I would hope that it wouldn't take so long to have that conversation. But friendly, definitely. Okay. Somebody says, look, I want to have that conversation too, a Zionist says. If a Jew is protected, even though he's not one of the classes, he's a Jew, one protected classes. I want my definition of a Jew in there too. So clearly, some definitions of Jew are in there and some aren't. And if the government has no right and should not define what's a Jew, simple question, how can they protect a Jew or somebody who says, I want Jews to all die, if you cannot define what a Jew is? How do they do that?
Okay, so first of all, Rabbi, again, I think we have to distinguish between Title VI and Title VII.
Agreed. Okay.
So with regard to Title VI, if you don't want to admit members of the Jewish religion, Ivanka Trump, because you just hate the religion, you think the religion is stupid, dirty, awful, you've not violated Title VI. Now, because it just doesn't cover religion, it does cover ancestry, at least according to these lower court decisions. So if you're not admitting somebody because of who their parents were or what ethnic group they come from, that's a different matter. Now, with regard to Title VII, here's a lawyerly distinction that I think is really important to maintain. Title VII does not prohibit anti-Semitism.
Right.
It doesn't prohibit you from hating Jews. It doesn't prohibit you from thinking they all ought to be exterminated. What it prohibits is an employment practice. Mm-hmm. So it prohibits refusing to hire somebody because of their religion. So the legal question is whether refusing to hire somebody because of their political views about Zionism is refusing to hire them because of their religion. And it seems to me pretty clear that it's not. Mm-hmm. It is true that many people who have religious commitments to Judaism also have a commitment to Zionism, but there are many Zionists who are not Jews, and many mm-hmm. anti-Zionists who are Jews.
I'm one of them.
And so am I. And it does seem to me to be really dangerous if you start saying that it's a Title VII violation to refuse to hire somebody because of a set of political commitments. Let's just put the shoe on the other foot for the moment. Mm-hmm. I'm a Zionist organization devoted to the continuation of the state of Israel. And there is a Muslim who applies, and I say, for me, Islam means Israel doesn't have a right to exist. And I refuse to hire that person. I'm sorry, that's not a Title VII violation. You have a right, pro-Zionist organizations have a right not to hire anti-Zionists. And by the same token, anti-Zionist organizations have a right not to hire people who are pro-Zionists.
So what's really happening, and then we'll move on, it seems to me that the more the Zionists define Jewish identity in terms of the political position called Zionism, the more they are moving, the more they're defining themselves out of the protection of Title VI and Title VII, because it makes it worse for them.
Right. That's right.
If a guy like Shimon Peres, according to him, a Jew, if the definition of a Jew is a Zionist as a Jew and Jew is a Zionist, then being a Jew is not protected at all.
Right.
If that's the case.
Right. That's right. I think that's right. And worse yet, it delegitimates the argument that we have against real anti-Semitism.
Yes, it does, because if like you said, if being a Jew involves at its essence a political position, and everybody knows you're allowed to oppose political positions. So in order to say anti-Semitism is bad, you have to say, no, this particular political position is off limits, which is a very hard argument to make. Which means that anti-Semitism has a much stronger case for its legitimacy if the IHRA definition is correct.
That is the deep irony and tragedy of what's going on right now.
Yeah. Okay, moving on. What would be the process, the legal process, if for some reason our government wanted to make anti-Zionism into anti-Semitism, to accept the IHRA definition into law? Would it depend on like local jurisdictions? Let's say even a Title VI case. Somebody would bring a Title VI suit against a college, or a Title VII suit against an employer. Who would have the jurisdiction over here? Would this depend on states, since I know that there are federally protected classes and then different protected classes varying by state? The IHRA definition would be under which legislative level, of authority over here? What would be the process?
Okay, so with regard to Title VI and Title VII, with regard to Title VI, there are a couple of things that might happen. So one thing is, Title VI is enforced by the Department of Education. So the Department of Education might threaten to cut off funds from a university that tolerated or endorsed anti-Zionist positions. And then there'd be litigation, presumably. The cutoff of funds might be challenged in a court, and the court would decide. Now, one thing that's really unfortunate here is that it may be possible for these folks to get their way without any court ever deciding, because the problem is universities are famously risk averse. They're not well known for having stiff spines. And so the mere threat of cutting off the funds might cause universities to act to suppress anti-Zionist speech, and it might never get to court. So that's a real danger. A second way it could come up, typically under Title VII, individual people who suffer what they think of as an employment discrimination bring lawsuits. And one could imagine a court holding, wrongly I believe, that discrimination based on belief about Zionism is religious or racial discrimination, and it could be litigated. So all of that would be on the federal level. Now, on top of that, of course, states have their own statutes, their own standards, and it's possible that something might happen under state law as well. I think the more immediate threat, though, is on the federal level.
Mm-hmm. So what I'm hearing, tell me if I'm right, is that the IHRA definition, by being accepted, by getting it to be accepted by so many countries, including State Department of this one, basically validated the threat of a lawsuit. Because without the IHRA definition, if somebody would come and say, I'm bringing a Title VI suit against you because you spoke bad about Zionism, that would be a frivolous lawsuit or a hopeless lawsuit. Because why in the world would anybody associate anti-Zionism with something that's protected under Title VI and even Title VII? But now that these countries, including our State Department, and President Biden said he would accepts the IHRA definition. President Trump, in an executive order, recommended that we accept it. It no longer could be considered frivolous or something to be thrown out.
Yes. So here's another irony. What these people are engaged in is essentially a political and a cultural struggle. It forces the idea that the Zionism is a political issue, and they're attacking it with a political campaign, and I might say so far a really successful one. And of course, they have every right to do that. They, like anybody else, they have a right to advance a political position, but just because they've been so successful, I think webinars like this are crucially important because, of course, we also have a right to oppose it, and we need to do what they are doing. That is to say, we need to organize, we need to speak out, we need to make arguments, we need to show what, in my view, is the ultimate absurdity of their position and just how counterproductive it is in terms of what I think is our mutual aim of combating authentic anti-Semitism.
Right. So speaking of arguments, based on what you're saying, can the following argument be made against the IHRA definition creating a actionable Title 6 or 7 situation? Let's assume that we accept the IHRA definition. Let's assume the country accepts it on a federal level. Everybody has to implement it. All the IHRA definition says is that anti-Zionism, at least to the extent that it describes it in the illustrations, is anti-Semitism. It doesn't say that Zionists are included in the definition of Jews. It doesn't say that. So I, as a defendant, as if I'm an employer and I don't want to hire a Zionist, can I not say, you know what? I'm an anti-Semite according to the IHRA definition, but the reason I'm an anti-Semite is not because I'm discriminating against a Jew. It's because I'm saying something that Jews don't like, and you expanded the definition of anti-Semitism to include that. But I'm discriminating against a Zionist, and there's nothing in the IHRA definition that says that I have to recognize a Zionist as a Jew or that a Zionist is a protected class. It says I'm an anti-Semite. I'll gladly be an anti-Semite. But anti-Semitism is not the same as discrimination, and it's not the same as harassment. So the law only, there are two issues: who the law protects and what it protects them against. The law protects them against harassment and discrimination, right? This says, the IHRA doesn't mention a thing about harassment or discrimination. It mentions anti-Semitism. What I will claim is that what the IHRA did is it expanded the definition of anti-Semitism to mean, you know what, I'm an anti-Semite, and I'm a bad guy if I say these things that Jews don't like. Zionism is still a political position, and if I speak about this political position negatively, okay, it's different than all other political positions. For whatever reason, that's what the law says. I'm guilty as charged of that. But I still didn't discriminate against a Jew, and I still didn't harass a Jew. I said so. The law, Title 6 and Title 7, does not protect somebody against anti-Semitism. And the IHRA definition does not impact on anything against which Title 6 and 7 protects people from. What do you think of that?
I think it's exactly right. So the word Jew does not appear in Title 6 or Title 7, and not the word anti-Semitism. And if they want to define anti-Semitism to include political positions, they have the right to do that. They're a private organization. They can define anything any way they want to, but that doesn't change the text of Title 6 and Title 7.
So we could really defend it. So now, okay. So we theoretically could at least defend against Title 6 and Title 7 by saying that, all right, so I'm an anti-Semite, so what? Anti-Semite isn't a legal terminology, it's a moral terminology, and but that doesn't mean I violated Title 6 or Title 7.
And you're right, and it's worth pointing out again that I'm speaking only for myself, but I may also be speaking for you, Rabbi, and this sounds bizarre to say, But if their definition of anti-Semitism is right, and they have the right to define it any way they want to, then I am a proud anti-Semite.
Right. In other words,
right?
Yeah, you know what it's like? It's like if, let's say, they would expand the definition of the word murder to include killing animals.
Right.
Fine. You know what? You want to look, the word killing applies to animals too. You killed an animal, you kill a person. By the way, you know, just as an aside, in the 10 Commandments, people translate the commandment, thou shalt not kill. That's not what it says. In Hebrew also, there's a word for kill, and that's not the word in the 10 Commandments. It says, thou shalt not murder. There's a different story. So if somebody expands the word murder to make it synonymous with the word kill, so if I kill an animal, that means I murdered him, right? That does not change the statutes or the elements of offense of murder to say that if I kill an animal, now you can put me in jail.
Well, that's right. That's right. But, you know, and maybe this is getting a little off the topic, but this is actually the way that political movements gain their goals. So what animal rights people want to do is to cause us to see, in their view, that killing animals is murder. So that maybe in a very long term, murder statutes will be interpreted to include killing animals. That's the same thing that the people who define Zionism as anti-Semitism are trying to do. And again, you know, it's a completely legitimate thing for them to try to do it. It is a political project, and it needs to be opposed on a political level by arguing for why that would be a bad thing rather than a good thing.
Right. See, by changing definitions of words, you can change definitions of words to whatever you want. Words change all the time. Usage changes all the time, and therefore so do definitions. But changing definitions is not going to change moral truths. What's right and right is wrong, regardless of whether you expand words like anti-Semitism into territory that's innocent and legitimate.
But sometimes definitions of words do have moral implications. And if you have a particular moral view, you might want to change the definition of a word to reflect that view.
Right. Language is a funny thing.
And then we can argue.
Language is a funny thing. People use words, but in the sense that you're describing, words are using people. If you describe something as murder, rather than say that it's an okay, you expanded murder to the word murder to include innocuous acts, people will say, oh, that's murder, therefore it's not innocuous anymore. Therefore it's wrong. And that's what the Zionists are banking on. The Zionists are banking on the word anti-Semitism to be saddled with so much negative connotations, rightfully so, that no matter where they expand it into, people will look at the new territory as equally anti-Semitic, equally bad, equally negative, equally immoral, wrong, and dangerous to Jews as what we all thought and knew was anti-Semitism. That's what they're banking on.
So I think you really put it perfectly when you said we want people to use words rather than words using people. So there is a real danger here that by kind of definitional fiat, people will obscure the moral stakes.
Exactly.
And you shouldn't be allowed to get away with that just by defining a word in a certain way. That ought not to pretermit or cut off the ultimate moral discussion about what the right thing and wrong thing to do is. And that happens way too often in our culture with a wide variety of words, you know, what it means to be an American, what racism is.
That's right. It happens all the time.
The great legal philosopher H.L.A. Hart once referred to definitional stops and the illegitimacy of a definitional stop. And what he meant by that was you cannot stop a conversation by a definition.
Right. Right. You know, I heard a video. I saw a video of one of the big Zionist activists, a former Knesset member, and somebody very in the top tiers of those who were involved in getting the IHRA definition implemented. And she said, you know, this is a war of words, she called it. And the Jews should be able to win this war of words. And I'm thinking to myself, first of all, it's not the Jews who are involved, it's the Zionists. So that's a wrong use of a word right there. But two, this is not a war of words. It's a war of right and wrong. It's a war of ideas. It's a war of understanding and common sense. They want to make it into a war of words, and we have to stop that. Now, as long as we're talking about, murder and words and killing animals, as long as we're going to use that analogy, I have one final question that I want to ask you. In all fairness to these Zionist students, okay, let's assume they're the most extreme in terms of defining Jews as Zionists. Let's say that they use Shimon Peres's definition. A Zionist is a Jew and a Jew is a Zionist, not merely that it's part of being a Jew or Jews need Israel or one of these things. That's what a Jew is. Now, I'm an Orthodox Jew, and as such, I eat meat. Not only is it permitted, but it's obligatory at certain times to eat a festive meal of meat. I understand at the same time vegetarians are not anti-Semites because they disagree with that, or even because they consider my practice evil. I also understand that a vegetarian that gets up and preaches that eating animals is evil and killing animals for food is evil, that's not hate speech. I got that. But what would happen if there would be vegetarian groups that would get up and say, you know what, killing animals is indeed murder and eating them is cannibalism. And because of that, Orthodox Jews such as myself would be looked at as murderers and cannibals and treated as such, including harassed and attacked, as one would do if you'd see a murderer walking down the street. How would we protect, let's say, students or even people who aren't students under such circumstances? The analogy is that there have been instances where Jewish students have been mistreated because people have said that Zionism is murder and Zionists are murderers. And never mind, I'm not even asking about Jews that are assumed to be Zionists that are not, okay? I'm talking about Jews that are really Zionists. How do we protect these students and non-students from the type of repercussions that will organically result, the invariable byproduct of people saying Zionists are murderers? Even it's their right to say that because that's not protected under these laws. But if people start saying that, how can we protect the people who are going to suffer because of that? And would we be entitled to say that at least such speech should be prohibited?
Okay, so there's a lot there to talk about.
Mm-hmm.
So what I would say, first of all, is if people are being attacked or harassed, depending exactly on what you mean by harassed,
Mm-hmm.
There are statutes against that. So if somebody is, if somebody burns down the the Jewish Student Association building, that's arson. Okay. You can be punished for that. Secondly, if people who oppose the eating of meat, if vegetarians choose just to go after Jews, that is religious or ancestry or race discrimination, depending on who they're going after, and that's not permitted under Title VI and Title VII. Now, but if they attack people who eat meat, I mean verbally attack them, and say they're murderers and what they're doing is wrong and it ought to be criminal, and they're going after anybody who eats meat, and it just happens some of them are Jews. That does not violate the law. In fact, they have a right to do that. And so First Amendment law is very strict about what exactly you have to show if you're going to demonstrate that speech triggers some sort of illegal action.
At what point do incitement laws come in over here? I mean, take a look at January 6th. We know what's going on with that, right? So at what point do incitement laws come in if you refer to people as murderers, and because of that, if a cause and effect can be established, would then a case be able to be brought under whatever law? I understand it's illegal to burn down meat eaters' homes, but those that say that meat eaters' homes deserve to be burnt down and that they're murderers and they're terrible for society, and that results in people choosing to commit those crimes. At what point does incitement come in? Because I know the Zionists are bringing this up too, and that seems to me like a valid concern, even if not a legally valid argument. A concern it certainly is, I believe.
Okay, so first of all, I just want to say this, I'm happy to talk about this, but this has very little to do with Title VI or Title VII, or it has to do with First Amendment law. So let me just first say briefly what the law is about this. So I stand second to no one in my opposition to what President Trump did on January 6th. But I do think under current legal standards, it's going to be tough to convict him of a criminal offense for what he did. And the reason for that is that the Supreme Court has held that speech is actionable only if there is a specific intent to incite people to engage in wrongful action, and if there is explicit incitement and an immediate threat, not something out in the distance, not something speculative, but immediate. And that's a very high barrier. Now, maybe the barrier ought to be lower, that we can have a good faith disagreement about that. And I do share your view that whatever the legal standard is, people need to think about the consequences of what they say. And so whether or not Donald Trump is prosecuted, what he did on January 6th, in my view, was completely reprehensible. And similarly, if people are engaged in really inflammatory rhetoric that they know or should know is going to produce serious harm to other human beings, they ought to think twice about it, for sure.
Thank you. Thank you, Professor Seidman. It's been a very educational experience for me, and I'm certain for our listeners as well, hearing you speak.
Thank you for inviting me. I too have learned from it, and I just wish discussions about these sorts of questions were more often on a level like this, that really thought seriously about them instead of just a lot of sloganeering and rabble-rousing.
Oh, let's make that a goal.
Okay, you're on.
Thank you. Thank you very much.
Tim, I'm very happy to see you. I'm Professor Wallace, as you know, but I'm chairman of ICMES, and I just wanted to make a few remarks. I think when we look at the series of webinars we've prepared, and I think Professor Mezvinsky, who's our president, will make some initial remarks. This series of webinars has been caused, or the occasion of this series is a definition which the IHRA has prepared on anti-Semitism. ICMES believes that one can have a fairly straightforward and simple definition. Essentially, it's prejudice against Jews. What IHRA has done, it has really conflated, or if you will, confused what being a Jew is confused that with Israel and with Zionism. In a sense, identified Jew, Israel, Zionism. And it suggests, this definition which they've prepared, that if you have doubts about or are hostile to Zionism, if you have doubts about or are hostile to Israel, that means you have doubts about or are hostile to Jews. You're an anti-Semite. But we think this is really foolish. It's inaccurate. It's mischievous. It's really pernicious. Being an anti-Semite is someone who has a prejudice against Jews, not someone who has political views about Israel or Zionism, or anti-Zionism, a whole lot of other issues. And this seminar, this series of webinars brings out what the root of the problem is. Namely, IHRA, as I've suggested, tries to identify Jew with Israel and Zionism, but even worse, it comes up with 10 or 12 illustrations. Now, that definition of theirs and those illustrations are the subject of what I think you and I agree, Tim, has been an extremely useful exchange between Yaakov Shapiro, Rabbi Shapiro, and Professor Seidman, my colleague at Georgetown, in which they really pull that apart. And they look at putting it in a legal context. They look at the Civil Rights Act of 1964, Articles 6 and 7, and show how those have been abused. And then, as I think we were saying before, they also look at issues of the First Amendment, which governs the public, states, and state universities. And I think all this is brought out really very effectively in the colloquy, the discussion, the exchanges between Rabbi Shapiro and Professor Seidman.
Don, I think that's very helpful. It's a wonderful introduction to what will come after us, which will be a discussion of and between experts on this subject. So I come to it also as a board member of ICMES, as a practicing attorney in Connecticut, a trial lawyer. I don't pretend to any deep expertise on this subject, but I do see at its root something that's fundamental beyond the particular question of anti-Semitism and whether anti-Zionism is anti-Semitism. It all begins with something we can agree upon as lay people and experts in any subject. It all begins with definitions. He who controls the definitions controls the narratives. And to borrow a word from your introductory statements, Don, it is people, individuals or groups who, when they have maybe malicious intention, they begin to toy with the definition and the meanings of words. And unless we're very careful, unless we confront definitions, which I would say are mischaracterizations of things and words and concepts, then our enterprise is doomed to failure. And the enterprise really is to get at what is the truth in this particular subject. What does Zionism mean? What is it? Does it have any nexus in rationality to a religion? Is it purely a political entity with political aims and goals? So the power to define, to borrow from another phrase, is the power to destroy, like taxation. And so we can't allow the definitions that are logical, reasonable, and universal to be marred, confused, to mislead people. So if we start with the definitions and we turn the matter over to the experts to get their opinions and insights onto what the meanings of words are, the conversation will follow much more logically. And while we may have input as lay people, and we'll have our own opinions, maybe once in a while even valuable opinions, but we can rely upon the experts. We can subject them to the same tests of rationality that we apply in the regular walks of our professional lives, and we can come to a just conclusion. That would be how I would say we introduce the subject to a wider audience.
Tim, thank you. I agree with what you said, and particularly with the kind of the essence of what you said at the beginning. As lawyers, we know that the drafter has the advantage. Let's say we're negotiating a contract and I say, I'll give you a first draft. The fellow who prepares the first draft has an enormous advantage, and you have to climb up the hill to kind of sometimes to undo what the draft, suggests. And I think that's what's happened with IAHR. They have tried to get the jump by coming up with a very elaborate, difficult, I think, as I indicated, mischievous definition. And now we have to climb up the hill to, in a sense, put the monkey back in the box, and it is a chore.